Okay, so welcome everyone. I know not a huge break, but hopefully we can get this started and get to the cocktails at a reasonable time. Or at least the reception. I may be overpromising in terms of what's actually available. So I'm Rebecca Tushnet. I'm going to be a minimalist moderator here because I'm eager to get to all the different presentations. Thank you. So I'd like to ask Graham Dutfield up to get us started.
Thank you, Rebecca.
And you'll have 12 minutes, and I may give you some notice.
Okay, I'll try and I'll talk fast. Sorry for the very long title. It's a real honour to be here to celebrate Jerry's distinguished career. I looked through his publications list, and I think, well, how on earth could anyone think of anything new and IP to write about that Jerry hasn't already covered? And I've known Jerry, I don't know how long I've known Jerry. I mean, there's a part of my life when I didn't know Jerry, and then I did, and I don't know where it happened. About 2001 or so, I think. One thing about Jerry that's impressed me more than just his amazing career is that for as long as I've known Jerry, I know he treats everybody the same. No airs and graces, right? A brilliant man who doesn't, who's not in any way pompous, and that's something I respect him enormously for. Okay, this sort of presentation is actually a half-written paper, and I was looking for somebody to write the other half, and I ended up asking my wife, "Do you know anybody who could help me write this paper?" And she said, "Well, why not me?" And I thought, why didn't I think of that? Yeah, so she's writing her part, but it's not yet done. Okay, so apologies for the gaps and holes in all of the arguments. It's partly her fault as well. Okay, so her name, by the way, is Uma Sutherson, so just in case you're wondering who my wife is. And it's motivated in a way because I'm also writing a history of the pharmaceutical industry, which is taking absolutely forever to write. And also some other things I've been writing recently. I wrote an article on Viagra. I don't know why they asked me to write that chapter, but I said, fine, okay, I'll do it. And it's for a book called History of IP in 50 Objects. So the object they gave me was Viagra. Not literally, obviously. So partly, I wanted to explore, the whole issue. Is it something other than just patents? Right, that raises issues about access, pricing, etc., etc. And I thought maybe we need to look a bit more at trademarks. Now, this particular case is rather unusual. It is a British case involving a medicine called Norlutin, which came on the market in 1936, right, for seizures. It's not, even the industry has not found a way to evergreen that product. That creator to find a way to evergreen that product over the last 80 years. But this is actually a competition case in the UK. Norlutin, this is Pfizer. Pfizer sold the marketing authorization to a company called Flynn, no relation, and obviously. And in the UK, we have these pricing regulations. What Flynn did was that they debranded the product, which meant they escaped from all price controls. Pfizer then became the sole supplier of the active ingredient to Flynn. They raised their prices to Flynn, and Flynn passed on that price increase and more. So this is pure. And then what Flynn did then was to block the importation of the branded Norlutin, the generic rather, under their own brand name, Norlutin, because of Pfizer's trademark, if that makes sense. Pfizer had a trademark on Norlutin, so parallel importation, I think from Italy, wherever it was blocked. I may have forgot some of the details slightly wrong there. Never mind. But the thing is that the Competition and Markets Authority imposed a very heavy fine on them, on both companies, but then what happened then was that there was an appeal, and basically they'd applied the wrong methodology to work out what was unfair and excessive pricing. So they basically got away with it. All right, so just a point here that trademarks do matter in a sense. And in fact, in my historical work, it seems to me, so I don't know what that stuff's there, blocking the headers of the, never mind, okay. It's like filling the blanks, okay. So, basically, the history of the pharmaceutical industry goes back to I would say about the 1880s, where we have something that we would now call something like the pharmaceutical industry, and at least 3, if not 4, of those antecedent companies are very much brand name businesses, not really patent industries. The top one is a patent and trademarks, but 2, 3, and 4 are all really, it's all about branding and marks. Okay, so signs, what is, I mean, if you look at, a pill itself, a tablet itself, without anything on it, plain packaging of pills and stuff, it conveys very little information. Well, it's a health product, right? So drugs themselves, they, in a way, well, as this historian said, Lentecker, drugs both contain and conceal their special powers against disease. So they need to be supplemented by signs, with a textual or visual that informs consumers or prescribers of their effects on the body. Informs. So I put those words in bold to think about those words. Okay. And what I want to talk a little bit about is about the visual aspects. Industry has known about this for a long time. If you think about Bayer, what do? They put the Bayer cross on the actual pill, which is quite a smart thing to do. I don't know if anyone actually thought of doing that before. They put the cross on the pill, so the pill starts to become sort of distinctive in a certain way. And actually, interestingly enough, the case in the US, Judge Learned Hand, who most of you have heard of, it's totally bizarre now. I was thinking, how did anyone get called Learned Hand? Anyway, who cares, really? But he actually said, basically, aspirin has 2 meanings, depending whether is it a pharmacist, wholesaler, or whether it is the person in the street. It actually has 2 meanings. It can be the essence, right? It can be the essence, which is unmoored from origins, or it can be origin. Its origin, it is buyer's associative acid. Okay, so 2 meanings. So it starts to get a little bit more complicated. With this, now you have you have shape, and you have also the colour, and you have the word Pfizer. I think we all probably know what that is, don't we? We all know that is Viagra. And of course, nowadays we see colours. Of course, this is very clever because the purple has been transferred to basically a Me Too product that's almost the same, but is branded as a completely different product. Zantac is, what is Zantac? What is it? Is that ranitidine? Not necessarily, right? Because now we have a product called Rapidol Express by Zantac. Is that the same stuff? Is that ranitidine? No, it is a branded extract of brown algae. It's used for the same medical purpose, and it is actually regulated not as a pharmaceutical product, as a medical device. Confused? Okay, so I will look back on some old cases involving visual aspects of pills. There was a case in the UK, 1972, one of the early ones that I found. I won't go into details, but, it's a UK case, so it's actually about get up and passing off as opposed to trademarks. The court came to it, I thought it was a rather strange decision, and I didn't even understand the last part of the sentence, to be honest, but clearly the colouring of the product was essentially, another company couldn't actually copy the colour of the pill. Is that a good or bad thing? I suspect there are some problems. You may have heard about AstraZeneca, and AstraZeneca has been, of course, in trouble over the years with the European competition authorities for their behaviour, particularly relating to Nexium, which some of you may know about. So the colour so the colour of these products is increasingly legally protected and is seen by companies as being valuable things. Does it, or any of this matter? Is it important? And as I say, the paper is still in progress. But a few sort of, actually, you can't see at the top, it says some tentative conclusions. Right, but it's at the top there, it doesn't fit on the page. So I'm not saying these are final conclusions, but these are things I want to try and confirm, and hopefully my co-author will help me to do this. One, I think we should look further in the patent system. We investigate impacts of life cycle management practices of drug companies. Trademarks form part of the whole IP strategy, last page, whole IP management strategy. I think competition law should reflect this, though, it may be hard to apply in a lot of these cases. Again, I haven't really explained why it might be a problem. Okay, first, branding based on trademark registration covering product names can generate confusion when their use blurs either the provenance, the origin, or the essence of the drug. So in conclusion, may in fact be part of the business strategy. Seems to me that's a public interest concern. Companies also anchor the product to perceptible elements. These are likely to produce additional confusion or even misinformation and reduce consumer benefits of cheaper substitutable products. That old British case was actually a compulsory licensing case, and the company could not use the same colour. I actually find that a bit problematic. And I'm going to try and defend the argument that it may be preferable either not to permit trademark protection for shape and colour, or else, with medicines, or else make them unenforceable against authorised generic products for the same indications. And here, I raised the interesting issue of placebo and nocebo effect, which is the opposite thing. Why should, if the colour has a placebo effect, why shouldn't that be transferred to the generic drug? Because otherwise you're making artificially and not substitutes. I see that as a problem. Also, it might be that the consumer or the medicine thinks, well, why isn't it blue? Why isn't it purple? Why is it not this shape? And actually we'll actually experience less positive therapeutic effects, or none at all. Again, I think that is a problem. And finally, for you trademark people, and I'm not one of those, in case you couldn't tell from my talk, the interesting question arises: do placebo and nocebo phenomena raise functionality issues for the purposes for trademark law? Thank you very much.
Thank you. Sean Flynn.
Okay.
All Flynns are related. Let's see, but except mine, here we go. Good. Okay, so thank you for having me, Ruth and Justin and the other folks who put together this great conference. It's amazing to be with so many fabulous people. And to Jerry for influencing all of our work. And so I wanted to return to some work I was involved in, almost a decade ago, because it's the work in which I met Jerry. So I was working with Jamie Love at the Consumer Project on Technology. At the time, we were advising the South African government on a complaint it had received that the refusal to license AIDS drugs was a violation of its competition policy. And we were dealing with a competition commission that was being advised by people from the US FTC, and they were saying, you can't do it. You can't use competition law to force the licensing of intellectual property. The two fields are completely separate. One cannot invade the other. And so my first job with working with Jamie was to find all the academics who thought differently. And one of the first people I found was Jerry Reichman. And so I will as well cite to the fair followers argument, because that's one of the first articles I read. Also, the Tulips article at that same time influenced us very directly. And we called Jerry and we said, here's our issue. Will you help us? And if anybody's ever worked with Jerry on an activism campaign, his answer is always immediately yes, right? There's some other people, Brooke Baker and others, who also are like that and gave us immediate yeses and worked on this project as well. But so the FAIR Followers article and argument that came out, I think it was about 1996, it was a couple of years after TRIPS passed, and a quite involved exposition of all the different ways that countries could implement TRIPS and implement what we now call flexibilities and be fair in the sense, and his definition of fair was really complying with the international standards, but taking advantage of the different ways you could implement those standards and still have follow-on, still have a degree of free riding. And one of the sections in that article that we found and therefore gave him the call was using competition law, that you don't have to only use the tools in the patent section of TRIPS itself or the various flexibilities within the IP sections, but you can use other aspects of law that have an impact on the power that patent and other intellectual property holders have. And I also found as I was rereading that work preparing for this talk some analogies to more of the work I'm currently doing. So I'm not doing as much access to medicines work now, I'm doing a lot more copyright work, and I found this great passage that points to a lot of the work I know that also Jerry's been doing recently, but rights to education and rights to research within the copyright system can also be seen as competition issues and should be dealt with similarly. So like Graham, I will say that it's not only patents and medicines that we find the opportunities to work in this area. So how do we do it? How do we craft the IP competition interface that answers some of these questions about aren't these two totally different doctrines? And to answer that, I'll reference some of the work from Louis Kaplos of this institution, who spent a lot of time trying to work through how to get to a proposal that is realist in the terms. So the current way that US courts do this, and have been doing it for many years, is the scope of the patent test. The competition authorities look at whether the action is within the scope of the patent, and if it is, it's fine. But that's what Felix Cohen would call transcendental nonsense, right? If competition law itself is cabining the power of the patent holder, then you can't use what the power of the patent holder is to define what the legitimate scope of that patent is. So you have to have a theory that stands outside of it and determines when the competition can restrain the scope of the patent, can define the scope of the patent to be more narrow, including hitting the core patent ability to exclude itself, including going to the core of the rights. And so what Louis Kaplow said is you should look at it's basically a ratio, that you can see these tools along a spectrum, and the more you have a small patentee award and a large monopoly loss, then you should be edging towards the competition side of the spectrum, and the more you have a large patent reward and a small monopoly loss, the more competition loss should stay outside. And so the question that came up in this South Africa case is, can we define a pattern in which that ratio is habitually on the side of the competition law side of the spectrum? So when should we use this tool? And the argument that I want to kind of put out here, that we've put out in different places, is that where that monopoly power is on essential goods and services, ones in which the demand curve will be highly inelastic because people can't do without that product, and you're in a country with extremely high income inequality, bringing in the developmental aspect, it will almost always be the case that the exertion of that monopoly power to its full extent will create a very small monopoly reward, a very small patentee reward, and a very huge monopoly loss. And so the argument that Edmund Kitch made in 1994, first of all, the first kind of, the positive analysis of the situation is that Edmund Kitch was wrong. that we did not see after TRIPS proportional reductions in prices in countries with less income. I was really interested in the presentation on India before, and my eyes perked up when he said, well, maybe it's just not profit maximizing to charge high prices in India. And then no, it just turns out you didn't have as strong monopoly rights, right? But I'd love to tease that out further. So this was the subject of some work that we were doing within that case, and that I later published with Aidan Hollis and Mike Palmetto, and it was basically working through an economic theory about why we see extremely high prices in very poor countries. And the answer is that, and so this is the United States at the top and South Africa at the bottom, and on your left-hand side, it's a demand curve based on distribution of income, and on the right, it's the revenue that you would make if you charged the price at which each decile of the population could afford. So in the United States, if you charge the price that only the top 10% can afford, you make less money than if you lower the price and serve more and lower the price and serve more. And so you end up with, you serve about 60% of the economy. But in South Africa, your profit maximizing price is very different. There's a small group of people who make global incomes, who make incomes on the standard of the first world, and most of the country that does not. And that creates a profit maximizing incentive to just serve those highest people, which is what we see. That's why we had $10,000 to $12,000 prices for AIDS drugs everywhere in the world. And even when, and this is a theoretical model kind of spelling out what that would be, but if we were right, and you sound out that graph, you actually find that the price of just serving the top 10%, the profit maximizing prices compared to Norway, you might even make more profit having a higher price in a poorer country, because you're not serving very much of it. And we see this in fact. So we could have drug examples, but we also have textbook examples. So books, like drugs, have essentially zero marginal costs to distribute the actual good. What you're paying is an intellectual property cost. There's no reason that it costs more to deliver a South African written book to South Africa than it does to the UK. But because you're not trying to serve the entire market, you can actually make more profit by having a higher price in a poorer country. So these are two examples of what we call exclusionary pricing, which is when you have strong enough market power, you can actually make more profit by having massive deadweight loss. And in the article, we actually show that it meets Lewis-Kaplow's test, right? So that profit maximizing price in South Africa creates 2 to 3 times as much deadweight loss as monopoly profit. And so we should be, under that test, restraining that exercise of market power, and competition law is one of the ways you can do it. And so what are the different ways? And here, I think, Jerry, I think it's a little bit of a report of the success of this work. And so we have the case, the Hazel-Tao case that I mentioned. The competition authority agreed with us. And they issued an order forcing the licensing of AIDS drugs in South Africa. And after that, and I interviewed some intellectual property attorneys a few years later, the advice that they began giving only to their AIDS drug suppliers was that any pharmaceutical company coming into the market, they were saying you have to give at least 4 to 5 licenses to local producers if you want to enter the market. That's what local IP attorneys were advising international entrants into the market, only for AIDS drugs. But we now have a UNDP report which adopts that similar framework and advises that this is the way we should interpret refusal to deal tests. We shouldn't look at a scope of the patent test. We should look at whether there's massive exclusion in the market and whether there's a refusal to deal that helps support that market power. That, I would say, is a good test. I think it's consistent with the fair following paper and some of the other work that Jerry has done, and I think it's going in the right direction. And then second, I just wanted to bring some newer material in from that second quote from Jerry's work about copyright law and about access to textbooks. So in South Africa, in general, there's a lot of locally produced textbooks that are relatively affordable, but especially for niche topics in which the textbook itself is really a global or northern textbook and South Africans have a small demand and they're not purchasing it locally, the textbooks can be 10 to 20 times higher price than normal textbooks. And so in the current South African copyright bill, which is on the president's desk right now, it implements a competition standard into its educational use clause. So generally, you may only use a portion of a work for educational uses unless Section 4. The right to make copies can extend to the entire work where it's out of print, where the owner can't be found, so orphan works, or where authorized copies of the same edition of the textbook are not for sale in the Republic or cannot be obtained at a price reasonably related to that normally charged in the Republic for comparable works. And if you go back to that section that Reichman wrote and the footnotes for that, he essentially brings out that specific language. I don't know if they were copying, it's from the Berne Convention, but he's pointing out the potential utility of that language, and at least one country is making use of it. So a couple examples of success. Thank you, Jerry, for influencing all of us, but especially me.
Duncan Matthews.
Well, I'd also like to begin by thanking the organizing team who did such a great job, to Ruth, to Justin, and to Irene, who did a lot of planning for today's event. And I really wanted to make this presentation, this short talk, a dedication to Jerry. And the way that I decided to do this was by focusing on one of your pieces of work, securing compliance with the TRIPS agreement after US and India. Now, Jerry, this is the first piece that I ask my master's students to read. So since 1998, every year, my students read this piece. So the number of students reading this in London now runs into the thousands. And I'm going to explain why I think this paper is still relevant today and why it was so prescient when you wrote this piece. So broadly, the piece was part of a wider body of work that you were engaged with about wiggle room in the gray areas in the TRIPS agreement. So it was about securing compliance with the TRIPS agreement by utilizing flexibilities. So again, this was very prescient because the discussion about TRIPS flexibilities was relatively underdeveloped at that time. But more than that, the paper was about maximizing the degree of competition in the markets that could be achieved by implementing TRIPS in a pro-competitive way. And you raised issues of good faith in terms of the implementation of international minimum standards. And that, again, was a theme that we saw referred to later, in particular in the Canada US Melbourne decision, the discussion of good faith more broadly. And when you talked about the pro-competitive mantle in the paper, you gave 5 examples. It was a non-exhaustive list of the types of tools that could be in the toolkit for developing countries to use. So you were talking more broadly than the utilization of competition law per se. But of course, you made explicit reference in this piece to Article 7 and Article 8 of the TRIPS agreement. And it's now to Article 8 that I'd like to refer more explicitly. Of course, in Article 8, Paragraph 2, we know that there is a potential for WTO members to prevent the abuse of intellectual property rights by a range of measures available under TRIPS, and Sean has referred to some of those earlier. And more recently, as Ruth knows, the United Nations Secretary General's high-level panel on access to medicines referred to the fact that Article 8, Paragraph 2 remains an underutilized flexibility in the TRIPS agreement. And I made a submission to the panel to that effect in 2016. I've also been working quite closely this year with the OECD. And what's impressive is at the OECD Competition Committee, the national competition enforcement agencies and the European Commission Directorate General Trade are looking extremely closely not only at excessive pricing and pay-for-delay agreements and vexatious litigation, but more interestingly, the enforcement agencies are looking at patenting strategies, the use of patent thickets, defensive patenting, what we call in Europe divisional applications, to cause noise and confusion in the patent system so that generic companies find that there are uncertainties when they're making commercial decisions about market entry with generic products. So the engagement on the competition side with some of these issues is certainly there. And at the TRIPS Council, we've also seen in the last year and a half that South Africa has taken the lead, supported initially by China and later by India and Brazil, in raising this issue at the TRIPS Council and not only acknowledging that competition law is one of the least discussed flexibilities, but actually are asking for an information gathering exercise to take place at the WTO TRIPS Council. Now, what's happened at the TRIPS Council from a European perspective is quite interesting because the European Commission is led at the WTO TRIPS Council by DG Trade. And DG Trade has pushed back against the discussion of this topic at the TRIPS Council. This is somewhat surprising to those of us who have been following what DG Competition has been doing in Brussels. You'll be aware that in 2009, the pharmaceutical sector inquiry of the Commission raised concerns about a number of the types of issues that I've been referring to in terms of patenting strategies. And this isn't just a topic which was being discussed 10 years ago at the Commission, because in January of this year, a review of those issues was published in an update to that report, again led by DG Competition. So patenting strategies, concerns which go beyond excessive pricing and pay for delay and vexatious litigation, remain a concern regionally within the EU. But as I've described earlier, what we're seeing is that in Geneva, another part of the European Commission is taking a different stance. So, linking back to Jerry's paper from 1998, the issues that Jerry was talking about in terms of utilizing flexibilities and using the full range of policy levers which are available under TRIPS remains as important today as it did in 1998. But what we seem to be seeing, and this was raised in the UN high-level panel's report, is there seems to be a degree of policy incoherence taking place, which is in the EU, preventing these issues from being discussed in perhaps a progressive way at the TRIPS Council, and ultimately, I think, can link back and have harmful effect in terms of how these issues are discussed regionally within the EU, undermining DG Competition's own concerns on this matter. And of course, in relation to developing countries, the immediate effect is that a simple information gathering activity, which South Africa and others have called for at the TRIPS Council, is being blocked. So, Jerry, your ideas remain as topical and as crucial as they did when you first wrote this piece and others. And I commend to everybody here your work and this piece in particular. And thank you again for your contribution to the academic debate. Jerry, thank you.
Pam Samuelson.
So I don't have slides. So I think at the time that Jerry and I were relatively young in the field, which was a while ago, it was very unusual for anybody in the copyright field to think about competition policy at all. And so one of my first exposures to the idea that competition policy should be considered within the framework of copyright law was actually work that Jerry presented. I met him for the first time at an ATRIP conference in 1989, actually, and he was presenting his computer programs as applied scientific know-how, which remains one of my very favorite, and I even saved the reprint and keep it on my shelf, actually. And I want to read a passage from it because Jerry and I were both speaking because the computer software issues were in 1989 kind of hot stuff. And so Bill Cornish from Cambridge had come over and Jerry and I were on the panel. I think that was us, but anyway, I had just done a paper basically saying copyright for computer programs, completely bad idea. So Jerry's work resonated with me, but it also brought me in touch with a much larger set of literatures than I had ever encountered before. And in addition, he had a perspective about what was really going on. This applied know-how concept was really powerful and very, very helpful to me. So this is one of the opening paragraphs of this paper. The bulk of today's most valuable innovations flow from incremental improvements in applied scientific know-how. Products of this new technologies that embody this know-how seldom behave in a manner consistent with the standard assumptions underlying the international patent and copyright systems. Legislative and judicial efforts to adapt domestic intellectual property laws to accommodate these new technologies have led to a proliferation of ad hoc protective solutions in all industrialized countries. However, these attempts to stimulate investment in innovative industries by tinkering with traditional intellectual property laws are short-sighted, and they tend to substitute problems of chronic overprotection for those of chronic underprotection. In the long run, the cumulative disadvantages of these responses threatens to inhibit the very forms of innovation they are meant to promote. And I was like, whoa, that's a different perspective. Now, the idea that there might be kind of a cycle of overprotection and then a cycle of underprotection was, again, a very powerful idea that was expressed in this particular paper. And it was the case that at the time that this conference was happening, the Whalen versus Jaslow decision out of the Third Circuit Court of Appeals had, shall I say, done the overprotection thing really, really great. So not only did the Whalen decision endorse the copyright protection for the structure, sequence, and organization, or SSO, of computer programs, but also the look and feel of computer programs, whatever that means. And the test that the Whalen decision rendered was that everything about a computer program, except its most general purpose or function, was was protectable expression, and only that general purpose or function, and everything that's like merged element, necessary, there's no other way to do something. And I'm going, that is completely whacked, okay? So, what happened was that Jerry and I began to not only through our scholarship, but also through more active engagement with our fellow intellectual property professors. So Jerry and I and Peter Manel and Dennis Cardula organized this Last Frontier conference at Arizona State University, and Rochelle Dreyfus and Paul Goldstein and a number of other intellectual property people were there, and Jerry and I had a real chance, partly through an economist who spoke, also through a computer scientist who spoke. We had a chance to really talk to the leading people in our field about what's going on in software copyright law, and we needed to sort of try to reach some consensus about what copyright should and should not be doing in respect of computer programs. And I think that conference really created a kind of baseline from which many of us did a lot of scholarship thereafter. So I will say that I have studied much of Jerry's work on these issues, and while our views about the Baker v. Selden case is not exactly the same, at least we could very much agree that the Nimmer Treatise's treatment of Baker v. Selden and its interpretation of Section 102B of the copyright statute that's supposed to be excluding processes, procedures, systems, and methods of operation from the scope of copyright protection can't just be just about abstract ideas and where there's no other way to do it, okay? Those words of exclusion must mean something, and the Whalen versus Jaslow case basically threw them out, just as the Nimmer Treatise had just thrown them out of the statute. And a treatise is not supposed to essentially repeal the statute, okay? That's not what its job is. After the ATRIP conference and after the ASU conference, I think Jerry and I both decided that we had to do something more active. So I started writing amicus briefs. Jerry and I collaborated on some of them. My main cause at the time was the Lotus v. Borland case, because the district court had followed Whalen versus Jaslow, but completely, saying that the command hierarchy of the Lotus 123 program was protectable expression, even though that very same judge had said that the command hierarchy and the exact order of the commands in the command hierarchy was a fundamental part of the functionality of the Lotus macro system. In other words, you can't execute macros that users had created. They couldn't use their own programs, and that just seemed completely wrong to me. So I wrote a brief. To the district court, to the Court of Appeals, the Supreme Court, and they blew it. Split 4-4. If only Justice Stevens hadn't recused himself, we would not be in the bad mess that we're in now. Anyway, I think it was good, at least that Borland succeeded at the First Circuit Court of Appeals, but I think it's really important that Jerry and I also collaborated on an amicus brief in the Sega versus Accolade case. The district judge had basically said that decompilation of computer programs, even for a purpose of trying to get access to interface information, was completely copyright infringement, and we were just, I'm telling you, all the money in the world was in the basket of decompilation was infringement. So it was really an uphill battle for us to come together and put together an argument. And I'll tell you, if you kind of read our brief and read the Ninth Circuit Court of Appeals decision eventually in Sega v. Accolade, they were really close. So we did a really good job on that particular thing. I think actually one of the things that's interesting is that because the Sega v. Accolade decision came out in favor of decompilation and said it's important to competition and ongoing innovation in the software industry, and the Computer Associates v. Altai case, very important to have competition and innovation and compatibility in the software industry. So we were like, oh God, that's really great. So this cycle of overprotection, right? Sort of like, oh God, okay, Sega v. Accolade, and the Altai decision basically goes, but then there's a threat of underprotection. And what you see actually in the most recent decisions by the Court of Appeals for the Federal Circuit in the Oracle v. Google case is, whoa, back up to Whalen versus Jaslow all over again. It's like, honestly, I already fought this battle once. I shouldn't have to do it again. But you do have to do what you have to do. So anyway, that's why I'm still writing amicus briefs in these cases. And Jerry has been a real pal on this and in so many other ways. But I would be remiss if I didn't also remind you that in the mid-1990s, Jerry and I and Mitch Kapor and Randy Davis wrote a paper about, right, if we're worried about cycles of over and then under protection, then if we want to say something that could maybe stop those cycles, it would be sort of thinking about what kind of what are computer programs, what kind of protection do they really need, and then thinking about what's valuable about programs is the industrial compilations of applied know-how. This is a Jerry thing. It's a Jerry phrase. He's very good at this, kind of green tulips and stuff. He's very good at good phrases, but I think that's still right. I think the interfaces that are issue in the Oracle v. Google case are industrial compilations of applied know-how. I think the behavior of computer programs is industrial compilations of applied know-how, and they're not suitable for copyright. They should be protected, if at all, through a sui generis right. And so while I'm not expecting that anything like that will happen anytime soon, it is the case that we were trying to think these things through some years ago, and we've been fighting the good fight for a long time. So thank you, Jerry.
Many of you, the enduring problem of cumulative and sequential innovation, which never goes away. Yeah. And we never address it head on, and that's the problem.
All right. Peter, you.
I need the password. It's
no.
close, yeah.
Then no.
Then no.
Sorry, it looks like it likes to misbehave.
I mean, your help, so let's see if I find.
See, Pam, there's a downside to not
I'm
using.
sorry,
That's all right, no
I
problem,
messed this up.
no problem. Yeah, let's open this one.
Or alternatively, everyone else has it wrong.
Exactly. It's the downside of being dependent on it.
Okay, sorry. Success.
Oh, there they are.
Okay, it's tough to follow Pam, but let me start by thanking the organizers, especially Ruth, Justin, and Irene. So this is the last presentation before reception. So what I'm going to do is to do a special presentation just for Jerry. And so what I've done is pick 3 different things that are very dear to my heart, but also I want to show the influence of Jerry's work and how his ideas are still relevant today. And so I have to apologize for a very long title, but Jerry loves long title, and so that's what he got right here. So the title is actually taken from an article that he wrote in 1993. This is 26 years ago. Jerry probably still remember those days where there's a conference in London where he actually talked about this paper. And so I think it would be perfect to actually link this together with intellectual property and competition law. And so as usual, for those of us who are in law school, we always have a sentence that we really love. And so I go back to some of my work to see which one that I keep on citing to Jerry, and it's this one. Policymakers concerned to promote investment in important new technologies often overstate the supposed benefits of specific intellectual property regimes while ignoring the negative economic functions of these regimes in relation to the complementary operations of competition law generally. And so what I'm going to do is to actually break this sentence down into two different components, and I'll start off with how a lot of people actually overstate the supposed benefits of the IP regime. And then I'll get into the other half is about complementary operations of competition law, which actually fits within what we have on this panel. And so in the last couple of years, I've been spending time writing about the new data producers' right for non-personal and anonymized data. And that's basically a proposal by the European Commission to cover machine-generated data. And that proposal came out 2 years ago, but now it has slowed down. And I think a lot of people actually is not focusing on that idea. But the reason why I think it's still quite important is because Japan has actually changed their unfair competition law, and that tackles a lot of the issue with respect to big data. I think this is the time where a lot of countries are paying attention to what's going on in Europe as well as in Japan in terms of how we're going to revamp our IP system in light of the issues. And that is actually understandable because there's always this a little bit misleading description, how data is the new oil. And for those of you who are from the intellectual property crowd, this is probably not the best metaphor right there. But we can also see that there have been a lot of data that are now collected by a lot of the machines within the Internet of Things era. And so that becomes increasingly valuable and important. If we go further to think about artificial intelligence and machine learning, you can see why a lot of countries they are very eager to think about ways so that they can get ahead in light of offering stronger protection to data. And one of the big questions that the European Commission were asking is that, well, how can we determine with respect to data ownership? And they look at the three different things. Should we actually give the ownership to car manufacturers, software manufacturers, or car owner if you're thinking about the machine-generated data collected by cars? But important question that we're actually not asking is, should data be owned in the first place, right? And I think that is a very important question. And that actually lead me to this article, Intellectual Property Rights in Data. And that's one of my most favorite articles. I don't know how many times I've read this one. It's also a deep honor to follow Pam because that was actually written by both Jerry and Pam. And that covers a lot of the different issues right there. But I think it's also quite important that you can pull out from the article is thinking about the modality of protection, right? Even if you assume that data is very valuable, you need to offer protection. You don't necessarily need to go all the way to your property rights. And so there are a lot of different modalities in between. So unfair competition obviously will be very attractive to Jerry, but there are a lot of different choices that a lot of the policymakers can consider in protecting data. And since that article, Jerry has written a number of articles with Paul on database protection, and their collaboration has continued even today with the latest book that has just come out from Cambridge University Press. So the second example I'm going to give you is about the complementary operation of competition law. And that's actually very important for people who are into intellectual property as well as the TRIPS agreement. And so what I'm going to do is to actually focus on something relating to the TRIPS negotiations. So if you remember the TRIPS negotiations, there were two different major draft texts. There's the A text and there's the B text. The A tax comes from the developed countries and include a lot of the provisions that we now have in the TRIPS agreement, whereas the B tax is put together quickly in light of the proposal by developed countries, and that include a lot of the provisions from the developing countries. And so some of the provisions that are included right here is basically those provisions that are drawn from some of the previous discussion in the UNCTAD code, as well as other issues that are very important to developing countries. But the reason why I think it's quite important is Article 40 is actually within the B text. Right, so there's a very important issue that's being incorporated into the TRIPS agreement. So I was actually very excited when there was the second case between US and China, where the USTR filed a complaint 2 years ago. And I was excited in part because this is the second case about a TRIPS agreement between the US and China. I'm also excited in light of the fact that it actually can shed light on a lot of those issues that are quite important to developing countries. So that complaint is basically about TRIPS Article 3, about natural treatment, as well as Article 28 is about the licensing contract in patent law. But what I'm really excited about is that some of the potential defenses can actually come from Article 40 of the TRIPS agreement. It's about abuse of intellectual property rights. If you look at the two different regulations that are involved with respect to this case, the first one is about technology import and export administration, and the second is about Sino-foreign equity joint ventures. Both of them cover a lot of those contractual provisions that are considered problematic, not just within the WTO, but all the way back to the 60s. And I think that is actually quite important. But it's also quite interesting that a lot of those provisions are already covered with respect in the draft International Code of Conduct on Transfer of Technology. And that is especially interesting for this particular event because Jerry actually worked at UNCTAD before he joined academia. And so if you look at a lot of the clauses right here, you can see that a lot of them are implicated with respect to that decision. And so it will be interesting to see how the WTO panel is going to address the issue. And it's also quite interesting that one of the panelists actually is a specialist in competition law that has been appointed to be the panel. Sadly, though, in June this year, they've decided to suspend the complaint, and it is unclear as to how that would play out, and most likely this will basically just lapse in light of the complaint. And so we're not going to be able to get the panel's interpretation of Article 40 with respect to that particular decision, and we have to wait for another time to get something like that. And the last example I want to focus on is basically something that will pull the two together, but also showcase how complicated and problematic those issues can be. And that's with respect to traditional knowledge. And traditional knowledge is special for me from the context of this conference in the sense that this is the first time I actually met Jerry in person. And I've talked to Jerry in the past. I believe this is also the first time I met Ruth in person. And that was way back in 2002 at Cardozo Law School. But I think I use this example because it brings together the two different issues I cover with respect to whether people actually overstate the importance of protection, and this is still debatable. If you ask the indigenous communities, their response will be very different from those scientists who want to focus on having more innovation. And it's the same thing, you also have to think about whether competition law actually should be interpreted the same way as we do in light of this very special issue. Do we actually want to encourage more competition in this space, right? So that raises a lot of very interesting issues. And when Jerry came over, and he is very eager to talk about this article, Green Tulips. And those of you here, I'm pretty sure you're very familiar with this one. If you are not, Jerry will make sure you know about it. And so there's no coincidence where we actually have the back, and that includes the green tulip right there. But since then, Jerry has also tied that discussion into an interesting chapter written by him and also Tracy Lewis, and for the book he edited with Keith Maskus. And that book actually came out of a very important conference at the Duke Law School. I think a number of you were actually there. And for me, I was a very baby academic at that time, and I got a chance to actually meet a lot of people there. And I think I was really gracious because Jerry has always been very generous. And he called me up and said, well, Peter, just come over. You want to meet a lot of those people right there. And over the years, he has been a great mentor. He has talked to a lot of different people. And I think that goes back to what Terry started off about how generous Jerry has been as a mentor. And he has also been to a lot of different conferences. And those, Irene and I have been a beneficiary of him coming over to our school to speak at our conferences. And he has also hosted us not only once, but also twice for the International IP roundtable that Irene put together. And so we go to Duke and we got to enjoy the wine that Jerry brought over. But at the same time, we also get to talk about very interesting ideas. So what I want to end on is this article. And this will bring back a lot of memory to Jerry. And this is actually the first article that Jerry published. And that's from 1983. And it's before most of us. And this one is actually a very interesting article. It's very long, though. But this article includes a lot of things actually from Italy. So you know Jerry loves Italian wine, Italian food, Italian clothes, and then you got a lot of examples from here. But what I want to focus on is really this one, which a lot of the law review editors care about, the asterisk footnote. So in that footnote, Jerry actually thanked people for the moral support. And this is just rare. You don't see this anymore. And I think you can actually tell two different things from Jerry. First one, he's always very generous and gracious, and that's why he's thanking people for moral support. But the other thing is the most important thing. When you wrote about intellectual property, forget about international intellectual property in those days, in the early 80s. It's very lonely, right? You need all the support you can get. But look around here. There are so many people actually doing international intellectual property. So let me end by thanking Jerry for opening up the space for all of us. Thank you very much.
So, Jerry, would you like to ask the first question?
I have no perspective. I'm just overwhelmed by your tributes, and thank you very much. And going back over these early articles and seeing where they led, it's been a wonderful pleasure for me, but it doesn't detract from all the wonderful things that you people have added to these original insights and directions that we should think about. I would just say what I thought about before. The problem we haven't solved globally is this problem of cumulative and sequential innovation, and it keeps driving these streams of overprotection and underprotection, and we seem to never get tired of it. And I think it's time that we found some way to stop listening or block the listening to the people who have a vested interest in every proposal that they're putting forward and try to find a solution that gets this off the board. Because as Pam showed, we go back and forth to the same cycles as if nothing had ever happened before, and you have to wonder. But of course you have to wonder what the Court of Appeals for the Federal Circuit was doing talking about computer programs to begin with, but that's another subject.
So, questions from Justin?
Sure. So, Pam, here's a question for you. First of all, I don't think you should be tired of the struggle because, if you're a good Hegelian or you're a bad Hegelian, it's thesis, antithesis, synthesis, antithesis, synthesis. Just get used to it. But absent Oracle and Google's struggle with each other, do you think that where copyright came out with software, considering all-time computer associates, considering the computer associates framework, was about as good as we likely would have gotten if we had attempted something sui generis?
Yes, I will admit that as someone who has endorsed sui generis solutions, I have come to recognize that there's foibles with that direction too. So kind of stiff filtration, I think the Bateman versus mnemonics and the Gates rubber decisions, which I think improved the Altai case by saying that you've got to filter out algorithms as unprotectable procedures. I think the Sega v. Accolade case talks about the interfaces necessary for interoperability as unprotectable procedures under Section 102B. So as long as there's some meaningful effort to kind of filter out things that are highly functional, then I think we ended up with not so bad an outcome because God knows the software industry is doing really well. But I will say that I just was teaching the Oracle v. Google decisions this last week, and I taught the fair use decision on Wednesday. And I assigned the students to read the Microsoft brief in support of the grant of cert on the fair use issue. And I thought that was, shall I say, not where Microsoft was in the 1980s and early 1990s, but a welcome change. And they said straight out, we need a flexible fair use for software, and the Court of Appeals for the Federal Circuit's decision on the fair use issue is not only rigid, it's disastrous, okay? And for Microsoft to use that language was like, oh my God, this is like really interesting. So the endorsement of compatibility. So it means that there's still people out there to fight for unprotectability of interfaces, and there may be a way for there to be the Google case presents a particularly difficult issue, and it's distinguishable from these other cases. So we could end up there. The reason I don't think we're going to get there is that it's so easy to put a patent claim in any complaint, and then you automatically go to the Federal Circuit and get to their rigid rules. So they've thrown out now the 102B defense. They've thrown out the merger defense. They've thrown out fair use. And if they had gone ahead with the Cisco versus Arista case, which got withdrawn from the Federal Circuit, they probably would have screwed up Santa Fe too. So there's no defenses left in software copyright law. That's the big problem right now.
Yes, please.
As you note, Pam, I've always been on your side in this, but I will note that the patent protection of software has been countercyclical with the copyright law. So when Lotus came out, we had we began that software patents, and then when software patents were hurt supposedly by Alice, then we had the rise of the Oracle Google case. But the question I have is as you may know, the Patent Office has put out a request for comments on protection of artificial intelligence. And one of the questions it raised was, do we need data protection? And I am very concerned about that, what they want to get at. And this goes to some of what Peter was talking about as well. I mean, do you have any insight on that? For those of you who are interested, the comment period's been extended to November 8th.
So I haven't been following that closely on that side. I will say that that one of the things that I've heard from some practicing lawyers in California, in the Bay Area, is that now that patents aren't available for computer programs, that's all the more reason why we need to have broad protection for SSO. I'm going, actually, that's not a good idea. But it is the case that they'll use the tools that are available, and so while I think that it's actually been healthy that 1,000 or more patents have been invalidated since the Alice decision, I think that the software industry doesn't really need patents as much as, but if there should be, then maybe there's a layer for copyright, a layer for patents, and then a layer where nobody gets protection except as trade secrets. And that kind of way of thinking about it is actually, I think, the most sensible thing that we can do.
Yes.
Well, I would just add that I was really puzzled by the Alice solution, by the Alice decision, because it struck me that where they were going was to try to put a foot forward in the direction of the European PTO's approach to software, the technical problem and solution, which actually has been quite workable. I have found their decisions really enlightening. And so I was hoping they would get there. Instead, they stopped at the first step instead of going forward, and they've made it in a way worse. Okay, 1,000 patents invalidated. In the abstract, that's okay because we have some ideas that the patent office don't really know what they're doing in computer programs. But on the other hand, it made me wonder how many of those patents might actually have been worth patenting if we had a proper approach. We don't have a proper approach. And you find the decisions indefensible, whereas even if in the European approach, even if they make an error, they can quickly correct it because you can point out, yeah, well, it wasn't the technical solution that you thought, and it wasn't the step that you thought, and then it goes away. So,
yeah. I think one of the major things about the Alice case was that there were 10 judges and there were 7 opinions, and actually, Judge O'Malley was one of the people who would have validated all of the Alice patents, which I think is one of the reasons why she perceived Google as trying to throw out copyright, and the Supreme Court's already thrown out patent, and God, the software industry needs some protection, so I'm damned if I'm not going to sort of make sure that copyright is meaningful, okay? I honestly think that O'Malley is kind of overreacting to Alice in the Oracle v. Google decision.
So we should take a couple more questions, but I want to make sure other people get the opportunity to participate on the panel. So I'm going to try and ask a broader question, and it's the one that I'm uniquely prepared to ask because I love advertising law. So the kind of unfair competition policy I know is about advertising law, and I think that relates to issues of overlapping protection. So especially with the people who've been talking about drugs, I'd be very interested to hear reactions to, say, treating some of these things as false advertising. And of course, the other live issue in the US is disparagement of biosimilars, which is a similar move to the trademark move, which is to say, although the mechanism of action, as far as we can tell, is the same, and it has exactly the same therapeutic effect, we're still going to say, but it's not exactly the same. So you should stick with, and apparently this is preventing price decreases with biosimilars and preventing their entry into the market. So I'd be interested in the panel's thoughts about sort of advertising law and unfair competition and your topics. So.
Yeah, let me try to take a crack. It's not an easy question. But so since you started with drugs, let me respond based on drugs. So I used to, and I think I've done that in writing as well, and say that, well, we should not call substandard drugs counterfeit drugs, right? Let me backtrack. We should not call generic drugs counterfeit drugs, right? We should actually think about whether it's substandard drugs or whether it is actually legitimate. And I think that is a much better way to do it because there are a lot of generic drugs that are equally effective, and that's why we should make the distinction. But in the last few years, after talking to more people, I realized that substandard drugs actually is equally problematic in the sense that different people may want different standard. You may have some people who want to have 100% effectiveness within the US, but some people may actually not be able to afford 100% effectiveness. If they get 60% in a developing country, would that be good enough, assuming that it's not too harmful? I would say it's not too harmful, it's not harmful, but at the same time, it's just not as effective. And that actually gets into the question as to how you advertise a lot of those products, right? Because you have to distinguish between the different products. One is legitimate, and the other is maybe legitimate, but at the same time doesn't have the same effectiveness. And that will actually allow, for example, advertising, trademark actually to come into play, and how you can distinguish the product and let the consumers know exactly the level of effectiveness.
Right, so of course, the flip side of this, the aggressive version of this is that the trademarks constitute false advertising to the extent that they represent some uniqueness.
So I don't have a great response to the legal question, because I don't know a lot about that part of unfair competition law, but I'll tell you, just factually, it's happening a ton in developing countries. There was a bunch of years ago, I was involved in some work in Kenya, and there was a reporter that we were working with that was covering some of the work, and he was interviewing the attorney for the Kenyan attorney for the multinational drug companies. And so he went into his office and was interviewing him, and he came out and he told me that there was a huge strategy chart on that attorney's wall, and printed in huge letters was, generic drugs are bad drugs. And that was their strategy, because they were losing the IP battle, they were losing the political battle. And so they, expressly had this strategy to downgrade the quality. And you find that everywhere. I mean, I find that in South Africa. I find it, everywhere you go, there's a sense, and it's propagated purposefully, that generic drugs are bad drugs. And that's definitely
And just
strategy.
a comment from my experience of working with the OECD and the competition authorities, the types of examples which are being discussed there are where the proprietary manufacturer, when the product comes off patent, are giving to doctors, to GPs, slips which say when the prescription is written and that prescription is taken to the chemist, that the product which should be dispensed should be the proprietary brand name drug, not the generic. So competition authorities in Europe are dealing with these types of problems regularly.
So last question.
So this is a question to Sean, and it relates a little bit back to the keynote presentation, because I noticed, obviously we're an academic group, but particularly in the work that you've done and the work that I'm familiar with, social movements have played a huge role in access to medicine, actually played a huge role in the Competition Commission case in South Africa. I mean, the initiative was brought from Treatment Action Campaign and others. And yet there was a little bit of a messy interface between the expertise that some people with new competition perspectives had with respect to existing competition law analysis in South Africa. The idea of using an essential facility or essential goods approach was different from what was being promoted by some of the technical experts in South Africa itself. So to me, it some way raises a question, which is those of us who are involved in kind of translational work or trying to really work with the social movements, this interface between expertise and pushing the envelope a little bit and going beyond what is kind of accepted wisdom, and still drawing on and amplifying the power and sharing power with the social movement that actually is pushing a lot of the change that we're looking for. So I just wondered if you're willing to reflect a little bit on that particular experience, because I think it's a good instructive example for people who do want their work to have traction on the ground, and how to work with the social movements that are really pushing some of these issues.
Oh, that's a tough question. That's bringing up some interesting history, right? So, so in the South Africa case, the local AIDS activist movement really wanted to press an excessive pricing theory. And we were brought in to advise the Competition Commission. And so we weren't working for the AIDS activists. And the Competition Commission, their experts were extremely skeptical about the excessive pricing provision. So the South African excessive pricing clause says a monopoly can't charge an excessive price, and an excessive price is a price that is unrelated to the value of the good and that is higher than that value. So all the economists in the room can give input on that. And they had their own economists, and their economists were from the FTC, and their economists were basically saying that definition has no substance, that there's no way to enforce. There's no way to determine what's higher than the value if other than the price that's being offered in the market. And so there was a lot of trepidation about what to do there. And I think our side had different views on kind of the, what was the most useful doctrine, and that a doctrine that focused on the refusal to allow competition in would be an easier one to kind of get through, an easier one to prove in the end of the day. The final commission said all of them are true. It found excessive pricing, it found a refusal to deal, and it found a refusal to access to an essential facility. But where do it'll be a question we can bring into the cocktail party about whether and at that point, as I said, we were working for the commission, not with the AIDS activists, but even if we were working with the AIDS activists, at what point do you as an expert kind of take a different substantive position that you think is getting to the same goal as the activists want, So should they determine at the end of the day the actual legal theory? And I think that's unclear when you do that. But it's a hard-fought decision where obviously if you have a strict client relationship, which we never had, but if you're part of a coalition and you have a different view than the local part of your coalition, how do you deal with that? It's a longer question for sure.
Well, thanks to all the panelists, and thanks to everyone, and hopefully they're about to set up for the reception so that we can move to enjoying that very quickly.
Okay.